Do you need more than a will? The short answer is absolutely yes. A will says who gets your assets, but that's not the only question when it comes to estate planning. A will only lets the courts know what would happen once you pass away. It nominates the people you want to help with the probate process. Full estate planning also covers what you would want to have happen in case of incapacity or disability. Who's in charge of your assets and your medical decisions and your pets or your minor children if you have young kids? Who's caring for them during that time? And then ultimately, who would be raising them if something were to happen? So you definitely need more than a will. Every adult, that's everyone over 18, needs a power of attorney, which gives someone you choose the power to be in charge of your assets as well as other powers you will want to select. You need a healthcare power of attorney to say who would be in charge of your medical decision making, as well as to provide that person with some guidance on your wishes about your treatment. It would only come into play if and when you were unable to make your own decisions. You need a living will, also called an advance directive for a natural death, which lets your caretakers know what you would want to have happen if you were ever on life support. It comes into play once doctors determine there are no more treatment options or hope for recovery. It's making an end-of-life decision ahead of time. You also need a HIPAA waiver for anyone you want to give permission to talk to your doctors and to find out what's going on, even if they aren't necessarily the decision maker for your care, so that your family members and loved ones can know how you're doing and speak with medical staff. And you need all of that in place in addition to your will. Whether you need a will or a will in a trust is a separate question, but definitely a will alone doesn't cover all of your estate planning needs. Also, if you're a parent of minors, you'll want the guardianship completely covered. Long-term guardianship, who would raise your children, is written in your will and ultimately a decision for the courts. But your signed legal documents carry a tremendous amount of weight. The courts do not know your family or your children. You do. But without the legal documents, without a will, the courts have to make their best guess as to what is in the best interest of the children. But the will is simply nominating guardians. There is obviously more to parenting than that. A will gets probated after your death, but very often we are incapacitated first. So you need to consider short-term guardianship for an emergency situation. If your children are very young or if a guardian would want some advice from you about what to do, it's important to write everything down. They would need basic information like schools, doctors, dentists, but perhaps also the not so basic, like hopes and dreams and fears. What kind of schools do you want them to go to? What types of churches, vacations, camps, extracurricular activities? That is a great way to supplement the rest of your planning to make sure that everyone ultimately knows and understands your wishes, your values, your guidance, and your stories to pass down. It's an essential piece of the planning. It's included in every plan I create, along with an emergency wallet card to make sure the information in your kids' protection plan is immediately available in a crisis, and that authorities would know you have a minor child at home or in school if you're injured while away from them. To learn more, watch my other videos, and to discuss your particular situation, schedule your complimentary call today.